Michigan Automobile Subrogation, the nuts and bolts, which has over 450 attendees registered, not including those in conference room, and this is a record breaker for us. So we hope it's a good one, and we hope you all enjoy it, and I look forward to reading your questions and comments at the end of the webinar. So just as a quick rundown of what I'm going to go through, we're going to do some very brief overview of automobile coverages in Michigan, and then just some really basic stuff on subrogation generally, and then go through the fun that is personal injury protection coverage in more detail. Anybody who's worked with it knows how not simple it is. Property protection's a little better, but not much, and we'll go through that a bit too. And then tort liability is kind of the heart of the whole thing as far as subrogation and automobile accidents goes in Michigan. So we're going to go through that fairly well in depth. And then we're going to talk about some no-fault specific subrogation and recovery options. Some of them are statutory. And then we're going to look at some common law stuff for the other folks out there who might be involved. And then following that, we are going to conclude this. And if you all have any questions, I look forward to answering them. Okay, so we're going to get started and looking at the automobile coverages here. And the big one is personal injury protection, or commonly known as PIP. And this provides medical expenses and 3 years of wage loss resulting from injury in an automobile accident or automobile related. It's all kind of crazy, and we'll go through that a bit more later. Property protection is a similar idea, where we're looking at, the no-fault system, and this is the property side of it. It definitely operates quite a bit differently from the PIP, but we can break that down later. And this covers damage to property of others caused by use of a motor vehicle, other than other motor vehicles typically, except for legally parked. And there also is residual liability, which provides protection if the insured is sued or legally responsible for injury or damage. Now, typically, this is kind of how we would envision automobile liability coverage, but all three of these are statutorily mandated by the Michigan legislature, so those you absolutely have to have in Michigan. Now, there are some optional coverages, which also would be familiar to most folks in the insurance game. And first here is collision. And so we have standard, and that pays for damage to the insured's vehicle regardless of fault, and the insured pays for the deductible. Broad is going to pay for damage to the insured vehicle regardless of fault, but the insured is only going to pay the deductible if they are more than 50% at fault. Limited collision coverage pays for damage to the insured's vehicle only if the insured was not more than 50% at fault, and the insured pays the deductible for that. So they've got some different pricing options for the consumers if they want to have that additional coverage, which probably is not a bad idea in Michigan, given the sort of odd overlap with tort law, tort liability, and the way property protection insurance works. So probably a good idea. Comprehensive coverage pays for other damages to the insured's vehicle, non-motor vehicle related losses, probably also a good idea. And then I think we're all familiar with uninsured or underinsured motorist coverage, which covers what the insured would legally be entitled to collect for injuries or damages caused by an uninsured or underinsured driver. And if they do write that coverage, the minimum limits for that are $20,000 per person and $40,000 per occurrence. So just some brief kind of overview of subrogation, the general kind of concepts at play here. It's broken down more or less between, there are statutory subrogation provisions relative to automobile coverage in Michigan, and then there are some common law concepts that could also come into play depending on the circumstances and the type of benefits that you've paid out or the type of coverage. So as far as statutory rights are concerned, The big one is Michigan Code, Section 531.16. And this gives the no-fault insurer some reimbursement and they would call it subtraction, or otherwise known as offset rights, under certain very limited circumstances. And this is where the insured effects a recovery on a tort claim for injury arising out of an accident occurring outside the state of Michigan, accidents involving adverse drivers who do not have the required security in effect, which would be those three that I talked about before. Okay, so that's personal protection, property protection, and residual liability, and also in cases of intentional injury. So there are also some limitations, fairly detailed, that go along with that, and we're going to discuss that as well. And if you look at 531.27, it shows us that Section 31.16 also applies to property protection insurers. So as far as these two go, I think you'll see once we look at the tort law situation that you're going to see quite a bit of similarities, or at least attempts by the legislature to bridge the gap, between these subrogation rights and the abolishment of tort law. And then we've also got a third provision, which I tend to see used a lot less, probably because uninsured motorists, are typically uncollectible, but a no-fault insurer can recover benefits and costs from the owner or registrant of a motor vehicle that does not have the required security in effect. So common law subrogation, this is pretty much the basic things that most of us, I'm sure, are familiar with, which is we've got two kinds of common law subrogation. There's legal subrogation, and that arises by operation of law. Typically, we would discuss that in terms of equitable subrogation, and I believe actually a lot of the Michigan cases do, but in this case that kind of establishes these two and is cited a lot by further case law down the road. This is what we're talking about. So this is just if you've paid something out and it should have been paid by someone else, then it's only fair, that you should have a right to the claim of the person who's lost you indemnified. Basic equitable subrogation principle. And then we have conventional subrogation, and that we would usually know as contractual subrogation. So most of you all out there who are insurers are going to have clauses in your contracts. I see very few that would not have it, that say, look, if we pay a loss under this policy, then we either are assigned the right to your claim against whoever caused the damage, or we're subrogated. The terms are used kind of interchangeably, even though that's not necessarily the best idea, I suppose. But yeah, that would be the two parts that we're all familiar with. And so now we're going to take a closer look at personal injury protection benefits, more commonly and lovingly known as PIP. Okay, so what we've got here is that you've got a required coverage, and the insurer is liable to pay benefits for accidental bodily injury arising out of the ownership, operation, maintenance, or use of a motor vehicle as a motor vehicle, subject to the provisions of the chapter. And those benefits are due under the chapter without regard to fault. So it doesn't matter who caused it, doesn't matter if they're negligent. Could be a one-car accident where you're insured, fell asleep at the wheel. You still would be liable as long as it's accidental and arising out of the ownership, operation, maintenance, or use of a motor vehicle as a motor vehicle. So that's generally when they would be payable, but then there's also this question of out-of-state accidents. And what happens there is we've got a special statutory provision, which is that they are payable for accidental bodily injury suffered in an accident occurring out of the state if A, it occurs within the United States, its territories, possessions, or in Canada, and the person whose injury is the basis of the claim was at the time of the accident either a named insured under a PIP policy, their spouse, or a resident relative, or they could be an occupant of a vehicle involved in the accident whose owner or registrant was insured under a PIP policy. And this last part here regarding the security approved by the Secretary of State, a lot of times that's dealing with self-insured situations, and but it would operate roughly the same way. So you can have an accident in the United States, could be in any state, could be Hawaii, could be Alaska, it doesn't matter. U.S. territories and possessions, and Canada. So Canada I've seen a couple times. I have not seen any in these other areas, but conceivably, if you're a no-fault insurer, you could have a claim pop up in Puerto Rico, Guam, American Samoa, U.S. Virgin Islands, or the Northern Mariana Islands, and that actually, I guess, includes their territorial waters and airspace too. So somehow you have someone who's an occupant of an insured motor vehicle in Guam and happens to sustain injuries in an automobile accident, you could be on the hook for some PIP benefits. And how this works is you've got they have to be the named insured under a PIP policy, or they have to be the spouse or resident relative, or the last person, they could be an occupant of a vehicle owned by someone who is insured under a PIP policy. So, you know, things get a little confusing with that, especially the way that the no-fault system tends to work. But nonetheless, you know, we do see a lot of claims where folks get injured in California or Indiana or Iowa, you know, Illinois and whatnot, and they still can make a claim for PIP benefits. And then we've got this issue of parked motor vehicles, and this can be a pretty complicated one. And the way that they structure it is they don't say, well, you know, benefits aren't payable for, you know, if you've got a parked motor vehicle or something like that. What they say is, well, that injury doesn't arise out of the ownership, operation, maintenance, or use of a parked vehicle unless. So if you've got a vehicle that was reasonably parked, which is basically what they say is not unreasonably parked, you know, that would create a risk of damage. You have injury was a result of physical contact with equipment permanently mounted on the vehicle, which might be something like, could be, I don't know, it's kind of a crane hook or tow cables or something of that nature, permanently mounted on the vehicle. Or if you've got property that is being lifted onto or lowered from the vehicle during the loading and unloading process, if you come into physical contact with that as well, you could have some liability for PIP benefits. Or kind of a simpler one, but I think looking at some of the case law, a tad bit goofier sometimes too, is the injury was sustained while occupying, entering into, or alighting, aka getting out of the vehicle. So, I mean, I've seen some weird stuff where it's like, you know, someone could slip on ice while they're trying to put their keys in the car and still potentially have access to PIP benefits, which I think is a little silly, but, you know, that's not up to me. It's up to Michigan. There are some exceptions to those exceptions, though. And this basically boils down to the involvement of work comp. So they have the, well, it's not, you know, rising out of the ownership, et cetera, unless, and now they say, well, even with that unless, we're also going to clarify that it does not arise out of ownership, operation, et cetera, of a parked vehicle if workers' compensation is available to an employee who sustains that injury in the scope of their employment while loading, unloading, or doing mechanical work, unless the injury involved use or operation of another vehicle, and entering into or alighting from the vehicle unless A, they were doing so immediately after the vehicle became disabled, or B, the injury involved the use or operation of another vehicle. The asterisk here presents a kind of interesting situation that seems to occur a lot more often in the case law than I would expect, but which is that they say, okay, another motor vehicle, though, does not include a motor vehicle that's being loaded onto or unloaded from or secured to a motor vehicle as cargo. So if you have, you know, cars that are being hauled around, you know, we all see those trailers with, you know, like six cars going to the dealership or whatever. So conceivably, if one of those, you know, rolled off and it wasn't insured, that would complicate things. And, if they were liable for workers' compensation as well, then you're not going to be looking at any PIP exposure for that. There are some other situations where a person is specifically not entitled to PIP benefits, and this is where if at the time of the accident any of the following circumstances existed. Okay, the person was using an unlawfully taken vehicle, which should be, stolen or without permission. The actual language of the statute does have some kind of caveat of, if they had a good faith belief that, they were allowed to take the vehicle or something, that might not apply. But generally speaking, if you have an unlawfully taken vehicle, you're not going to be entitled to PIP benefits. Second, the person was the owner or registrant of an uninsured motor vehicle involved in the accident. So if you're driving around in your uninsured vehicle, you're not going to be able to claim PIP benefits even under another policy. Third, the person is not a Michigan resident, was occupying a motor vehicle not registered in Michigan, and was not insured by an insurer which has filed a certification with the Secretary of State. So that's kind of a three-pronged thing we're looking at there. You've got someone who, like I said, you live outside of Michigan, you're inside a vehicle that's not registered in Michigan, has nothing to do with Michigan, and is not insured by an insurer which has filed a certification with the Secretary of State. But that goes down to another statutory thing that I'm not going to talk about today. It's a little more rare, but basically PIP insurers are supposed to file certificates or certifications with the Secretary of State, and if they do that, they could be liable for PIP benefits for out-of-state residents under similar circumstances as this. If they have insurance with, like, Acme Insurance Company, and they're an Iowa resident, this is for their Iowa vehicle, but Acme is on the no-fault certification list, then they could, if they're injured in an accident in Michigan, they might have some access to PIP benefits there. Okay, so what type of benefits are payable? The big one tends to be medical expenses, and there's no time limit on there, there's no money limit on there. I mean, you'll have stuff about reasonable expenses and all that sort of thing. They can't just, be liable for whatever the physician wants to bill, but or conceivably. There's no $1 million limit or $500,000 limit. It doesn't matter. It could rack up benefits up to $1 million, and you're still going to be liable for that. There are some things that come into play as far as getting reimbursement from either other carriers or what's called the CAT fund. But generally speaking, without that, they have to pay out whatever. Wage loss is limited for 3 years. It's essentially, I believe, the gross income of the claimant reduced by 15%, and there is a monthly maximum on that, which is currently at $5,282 a month. But I believe that is probably going to change in the next month or so. I haven't seen anything new posted, but I think that figure only goes through till early or mid-October. Replacement services, household services and things like that, if you have to have someone else helping you out with your ordinary stuff, grocery shopping or things like that, I don't know. That's at a maximum of $20 per day. And there also is a provision for survivor's loss, which would, I guess, be kind of akin to a survival or wrongful death claim, which you're talking about economic contribution into the household. And that has the same limits on it as the wage loss currently. So offsets. There are essentially two offsets that you can do for PIP benefits. The first is those that are provided or required to be provided under the laws of any state or the federal government, and that is to be subtracted from the personal protection insurance benefits otherwise payable. So mainly that's workers' compensation. That tends to be the big one, and that is mandatory. So, I mean, you're always going to see it in all the policies, but, it's not really discretionary. I'm inclined to believe that even if it wasn't in there, it still would be offset by statute. The second is discretionary. The statute here gives an option if they want to offer what's called coordinated coverage, where they can have deductibles and exclusions reasonably related to other health and accident coverage. for an appropriately reduced premium. That tends to happen a lot. I'm sure you all know that better than anybody out there in the audience. But it's not mandatory, it's not automatic, so if it's not in there, there's not just going to be an offset. I can talk about that a little bit more later. And the other thing to note about that is that these exclusions do only apply to the named insured, the spouse, or resident relative. So if you had a passenger or something like that who under the priority rules that we're going to get into in a second would be be able to avail themselves of PIP benefits under your policy, you wouldn't be able to coordinate the coverage under that. And so, you can talk about priority for a second here. This is always a fun one because it doesn't always seem to get resolved so easily, but I guess there's good reason for that, especially for high-value claims, and there's legitimate disputes all around. But if you're looking at someone who's just generally an occupant of a vehicle, their first stop is supposed to be their own insurer. So if I'm insured under a policy with Acme and I'm injured in a motor vehicle accident while I'm a passenger of a car insured by some other company, we'll say Beta Insurance Company, I'm still supposed to go back to Acme. And I still would have access to coverage if it was my spouse, or let's say if I was a teenager or something and I lived with my dad and he had a policy and I was in an accident in a friend's car or something like that, I still would go to dad's insurer. There are some other perceptions for folks that are, if you're in a vehicle in the business of transporting passengers, if you're looking at buses, things like that, basically, hauling people around for hire, you look to the insurer of the vehicle. If you are an occupant of an employer-owned vehicle, so if I'm an employee and I'm driving around in my employer's truck and I'm injured in an accident, then I'm supposed to look to the insurer of that vehicle and not to my own insurer in that situation. This gets kind of screwy when you're dealing with kind of fuzzy employment relationships, but generally speaking, that's the idea. And if none of those apply, then you look to the insurer of the owner or registrant of the vehicle involved, and second, the insurer of the operator of the vehicle. If you're not an occupant of a vehicle, you still would look to your own insurer. That's kind of the default there, and that's who you're looking at first. And then you would go to the insurer of your spouse or resident relative, insurers of the owners or registrants of the vehicles involved, or the insurers of the operators of the involved vehicles, in that order again. Operators or passengers of motorcycles. First, you're going to look to the owner or registrant of the involved motor vehicle, so not the motorcycle. Second, the insurer or operator of the motor vehicle. And third, the owner or registrant of the motorcycle. So motorcycle gets last on there somehow. Out-of-state accidents, the priority question. I think this is kind of an interesting one, but because the provision, enabling out-of-state accidents to have access to PIP benefits actually doesn't have a priority scheme to it. The way that it's written, I would personally read it as you could have co-primary people if someone was, named insured on one's policy and, spouse was named insured on another policy. But this case here, Lamont versus Millers, actually sets forth that, no, we're going to go back to 3114.1 to determine priority. And if I wasn't clear about that before, generally what the statute says is that, okay, you're entitled to benefits either as a named insured or as the spouse of a named insured, right? But if you potentially have access to benefits under both, then you would only be entitled under your own insurance where you're named insured, and the spouse's insurer actually gets off the hook for that one. Property protection, we'll go into this briefly here. So we got section 531.21, and that says that the insurer is liable to pay benefits for accidental damage to tangible property arising out of the ownership, operation, maintenance, or use of a motor vehicle. So basically, if you hit somebody else's house or something like that, or I guess even conceivably run over their dog, that is tangible property, that's payable without regard to fault, and it is considered accidental unless it is suffered or caused intentionally by the claimant. So when they're talking about intent, you have to be looking to the claimant and not to the person who actually caused the damage. This does not include damage to property that occurs within the business of repairing, servicing, or otherwise maintaining motor vehicles. And it includes physical injury, destruction, loss of use. Limits are $1 million. And we're looking at the lesser of reasonable repair costs or replacement costs, less depreciation, and, if applicable, value of loss of use. And we've got some exclusions here. We're looking at vehicles and their contents are excluded, so you wouldn't look to property protection benefits if somebody's got a damaged motor vehicle. Two moving vehicles, that doesn't count. If someone conceivably slammed into your car while it was reasonably parked, you might be able to recover for that. Property owned by a named insured with their spouse or a resident. If their spouse or a resident relative was the owner, registrant, or operator of a vehicle involved in an accident which caused the damage. There's no property protection for accidents occurring outside of Michigan. And we've got some regulatory issues with damage to utility transmission lines, wires, or cables, and whatnot. So priority for accidental property damage goes to, 1, the insurer of the owner or registrant of the vehicles involved, and 2, next in line is insurers of the operators of the vehicles involved. So with these priority rules, you kind of have to distinguish between who's the owner / registrant of a vehicle and the operator of a vehicle. A lot of times the owner or registrant is going to be first, though. So before we get moving on to tort liability, I am going to put out there our trivia question, which the winner will have their choice of, I believe they have their choice of the our books that we have, which includes automobile insurance, subrogation in all 50 states. I'm going to read the question, and whoever's got the answer can either submit it through the GoToWebinar system, or they can email it to our marketing coordinator, Jamie Breen, which is jbreen at mwl-law.com. And the question is, what was the original name of the University of Michigan? Okay, so tort liability. This is the big one, and this is what tends to screw everything up. It's not necessarily the no-fault system in and of itself, that we've got certain types of benefits that are payable. It's just that, you're talking about subrogation where, whether it's statutory, contractual, or whatever, you say, all right, I'm standing in the shoes of someone else. Well, the question is, what kind of shoes are they? Where can you walk in them? And this is where everything gets screwy, because under 3135, well, 1, 2, and 3, not just on this slide, but it's a general just wiping out of tort liability arising from use, operation, etc. of motor vehicles in the state of Michigan. And there are very specific circumstances where you can or can't pursue a claim, and so that in turn places the same limits on whoever would be subrogated to the injured party's claim. So here we've got a person remains subject to tort liability for non-economic loss, so we're talking about pain and suffering and things like that, caused by ownership, maintenance, or use of a motor vehicle only if they have suffered death, serious impairment of a body function, or permanent serious disfigurement. So these are called threshold injuries. And, it's always kind of a subject of debate, but, you're looking for larger losses on that. I mean, at least a semi-substantial back injury or something like that. It really depends on whether, it impairs their kind of bodily function in their daily life. The bar used to be higher, I think, but sometime in the last 10 years, it seems like it got lowered substantially based on the case law. If anybody else, has any notes on that, I'd love to hear what their take is on it. But so comparative fault also applies under this statutory section, and there's not going to be any damages available for uninsured claimants. And I note here that there's no geographical limitation on that. You know, it could be an accident in or out of state, which kind of comes into play a little bit further when we get to Section 3. Because this is that tort liability arising from the ownership, maintenance, or use of a motor vehicle within this state, so i.e. in Michigan, with respect to the security, with respect to which the security required was in effect, is abolished, so there is none, except as to intentionally caused harm, damages for certain economic losses, or non-economic losses, which actually we covered in the last slide. These got switched around. Work loss, expenses, and survivor's loss in excess of the PIP benefits. So you know how we said that, well, there's a cap at X monthly amount and it stops at 3 years. Well, that would conceivably be available still for economic losses in a tort lawsuit, whatever's in excess of that. So if I thought, you know, my wage losses were $100,000 and due to the limits on PIP I only received $50,000 or something like that, you could conceivably pursue the excess amount. And also, yeah, it goes for work loss expenses and economic loss in excess of those provided under 3163.4. So this is what I was talking about earlier with out-of-state residents. I believe their available benefits are capped at like $500,000 or something like that. So if they had losses in excess of that, then they could pursue it. So there's only tort liabilities abolished. You know, you could conceivably look to some other things, such as, you know, contracts, products liability. Contracts usually a good way to go if you can find that. And it has to arise out of the ownership, maintenance, or use of a motor vehicle, and it only applies within the state. So now we've got mini tort, which I do tend to get a lot of questions about, but unfortunately I don't often have too many great things to say about it to people. It's pretty limited. Basically, this says that, you know, there could be damage to a motor vehicle is still available in tort up to a limit of $1,000, and this is to the extent that the damages are not covered by insurance. And that is assessed on the basis of comparative fault. If at all possible, you have to commence that in the small claims court. You can move the action to a higher court, but if you don't prevail, the court may assess costs for doing that. And any decision by the court is not res judicata, you know, or in other words, not binding in any other proceeding to determine other liability. So, you know, say PIP benefits or some other tort lawsuit for non-economic damages or something of that nature. The damages will not be assessed if the damaged motor vehicle is being operated without the required insurance in effect. So my take on this is I do get a lot of questions about mini tort. Generally speaking, I think it's going to apply almost all of the time. I've gotten a lot of questions about it, and I still have yet to see any really sort of interesting loophole. As far as subrogation goes, my personal view on it is just in sort of like the nerdy academic perspective, is that, you know, it only allows tort liability for stuff that's not covered by insurance. So if you're trying to recover insurance payments, there's really a logical disconnect in my opinion. But it does seem to me that it's done a lot, or at least attempted. And I guess that would probably stem from, in Michigan, you can pursue the insurance deductible, and there's no specific statute or regulation saying that you have to reimburse it. So unless that's in your policy, I suppose you could do that. Okay, so we'll go through some of the no-fault specific subrogation and recovery provisions here. And what I've done here over the next few slides is try to kind of explode the statute so we can take a closer look at it and pull out the more essential elements of it. So a subtraction from personal protection insurance benefits shall not be made because of the value of a claim in tort based on the same accident, accidental bodily injury. So you can't just simply say, well, you were injured in an accident, and so we think that your tort claim's worth $100,000, so we're just not going to pay benefits until they exceed $100,000. Number two, A subtraction from or reimbursement for personal protection insurance shall be made only if the recovery is realized upon a tort claim. Okay, so there has to be a recovery arising from an accident occurring outside the state. So we've got an out-of-state accident, a tort claim brought within the state against the owner or operator of without respect to which the security required by 3101 or just your required no-fault coverages was not in effect, so an uninsured driver, or a tort claim brought in the state based on intentionally caused harm to persons or property. So we're looking at out-of-state accident, uninsured motorist, intentional harm. So that's the general availability of that. But it shall only be made to the extent that the recovery is for damages which the claimant has received or would otherwise be entitled to receive personal protection insurance benefits. And what that means is that there's got to be some kind of overlap. You know, it's just the general double recovery principle. So if they say, well, it's all non-economic losses or, PIP in excess or economic damages in excess of PIP, that's going to be a problem. The same thing applies to subtraction only to the extent of the recovery, exclusive of reasonable attorney's fees and other reasonable expenses incurred in affecting recovery. So we're looking at basically a common fund reduction on the recovery for attorney's fees and costs that the insured would otherwise incur in pursuing that recovery. And if personal protection insurance benefits have already been received, okay, so now we're not talking about an offset, we're talking about reimbursement, the claimant has to repay to the insurer out of the recovery a sum equal to the benefits received, but not more than the recovery exclusive of reasonable attorney's fees, other reasonable expenses incurred in effecting the recovery. So, and the insurer shall have a lien on the recovery to this extent. So what we're looking at there is that you have a statutory right to reimbursement, but the maximum is the amount of the recovery less costs and fees. And so then statutorily, not only do you have a right to reimbursement, but it specifically states that you have a lien on the recovery to that extent. A subtraction or reimbursement shall not be due to the claimant's insurer from the portion of recovery to the extent that the recovery is realized for non-economic loss, which we talked about before, talking about pain and suffering, things of that nature, or for allowable expenses, work loss, survivor's loss, in excess of the amount recovered by the claimant from his or her insurer. So what we're looking at there is that this, again, is sort of mirroring this tort liability limits. If you guys recall, economic damages would be available for the expenses, work loss, and survivor's loss in excess of the amount recovered by the claimant from his or her insurer. So that's what's available, but they're not going to, it's like they don't want to allow the insured to have that claim and then also just have them have to pay it right back to the insurer. So non-economic loss, I think, tends to be the more popular sort of recovery that folks get when they're facing PIP liens. I'll talk about that in a second. But generally speaking, yeah. So they're saying if there's no overlap, you can't recover, which is, a basic subrogation principle, but a little more specific and statutorily mandated in this case. So now let's suppose that an insurer has a right of reimbursement and they weren't able to collect it because, let's say, the other excess liability insurer was, just paid over the funds to the claimant, and the claimant, absconded with them back to wherever they came from. So a personal protection insurer with a right of reimbursement, if suffering loss from inability to collect reimbursement out of a payment received by a claimant, is entitled to indemnity from a person who, with notice of the insurer's interest, made the payment to the claimant without making the claimant and the insurer joint payees as their interest may appear, or without obtaining the insurer's consent to a different method of payment. So they're entitled to indemnity for anyone who dispersed this money over with knowledge of this PIP lien or reimbursement claim and did it without either making the insurer a joint payee or obtaining the insurer's consent before doing so. So that's your statutory right of indemnity there. It's, you know, kind of, I guess, I don't know what other legal box I would put that in, but it's pretty convenient if you've got the right facts for it. But here's what happens a little too often, and it's something that I would suggest everybody look out for. And this is to kind of squirrel their way around. Well, I don't want to impugn anybody or cast aspersions on practice, I guess, but typically, if you've got a large PIP lien and you have maybe some policy limits or you're looking at a large settlement, here's the situation. So you have an insured who's got a tort claim against some third party, right, and they have, you know, a good claim against them and everything like that, notwithstanding the tort liability problems. And if the PIP's got a large lien and if they honor it, it's not going to give the claimants as much as they want. Third party, on the other hand, they want to get done with the claim, they want to settle it out, but they don't want to pay any more money on it because they've already adjusted the loss, and they say this is what we think it's worth. And at the same time, they don't want to tender the funds over to the claimant without resolving the liens because they don't want to have any of that indemnification problems that we just discussed above. So what happens a little too often is that the insured and the tortfeasor are familiar with the case law and the statute, and they know that, well, you know, if let's say this is all non-economic damages, we're just going to go ahead and say, well, you know what, either we filed suit already only for non-economic damages and wage losses in excess of PIP, right, and we're going to settle for only that. So basically that's saying in both the complaint and the release that there's no double recovery here, there's nothing for a lien attached to, and so they settle the case, they get an approval from the trial court for that and say, hey, look, we want to settle this. And so, you know, the court looks at it, don't really, you know, say, hey, fine, this is reasonable, it's all pain and suffering, we're good to go. And essentially it's going to cut out the PIP lien. And unfortunately, you know, there's just a number of cases out there. Here's 3 of them, and we've obviously, with so much ground to cover, can't necessarily go into too much detail about it all. But basically, that pattern of the way things work, they uphold it. They say, well, you know, the trial court approved this. We think it's pretty reasonable. And so even on appeal, we're not going to overturn it because we don't think the court's approval was an abuse of discretion. The release says this is what the damages were for. The court okayed that. The complaint said this. So PIP carrier, you have no lien, which is really unfortunate. I think probably something ought to change about that because in certain circumstances, if you're dealing with policy limits, I can see how maybe there's, you know, something legitimate to that, but it's gotten a little too easy to gerrymander settlements to the detriment of the subrogee. So what can you do about it? Make sure everyone is on notice, first of all, any third parties, because that at least would expose them to that indemnity provision for, you know, paying over without making the joint payee, and that at least is hopefully going to stop things up long enough for you to work things out with the claimant. Because a lot of times what they're going to want to do is hold on to that check to avoid any sort of exposure. Make sure you are on notice, right? Which I mean, make sure you know what's going on. Keep your eyes peeled. Make sure you know what's going on with the claimant, with defense counsel. Are they settling? Is there a legitimate dispute about damages? You know, just kind of get your foot in the door or stick your nose in things as much as you can. And consider intervention or independent litigation. You know, these aren't fail-safes, and you know some of the stuff can get really difficult too. But you know, if you intervene, at least you're on notice of things, and you can kind of be in a better position to object to the settlement or you know the motion for court approval of the settlement. Although the way that a lot of the case law is written, if they went along with it, they'd probably be likely to say that, well, you don't really have any right to object to it regardless. But conceivably, you can look at bringing a third-party tort claim too. We'll talk about that in a second, which you know at least might give you some sort of a better claim against the third party other than just trying to either get indemnity over the settlement or trying to seek reimbursement on your subrogation lien from the claimant. And you know, just generally stay vigilant and proactive to try and make sure that this doesn't happen. Important note there at the bottom, an action by an insurer for reimbursement or indemnity has to be brought within 1 year from the date the insured receives payment. So definitely keep that in mind, but negotiating things out and settling things is typically, I think, a good way to go. But if you are going to have to go to court for that, you've got to do it within 1 year, so make sure you're staying on top of your deadlines. Uninsured motorists, we kind of talked about this already. Obligated to pay PIP benefits arising out of ownership, maintenance, or use of an uninsured motor vehicle can recover those benefits paid and appropriate loss adjustment costs from the owner or registrant of the vehicle or from his or her estate. So you got a statutory recovery right here. This is not a subrogation claim. This is statutory recovery. It includes cost of the loss adjustment, which is very nice also. Failure to pay the judgment is a ground for suspension of the license and registration. And as you can see, his case law down here very conveniently says, well, we don't see anything here saying that that's got to be tied to fault. So even if it's uninsured, if you've got it involved in an accident, you conceivably can recover under that ground. Recoupment between insurers, we got this is down at the bottom of 3115-2. When you got two insurers that are in the same order of priority, then the one who pays it can seek partial recoupment from the other. So you're looking at a pro rata reimbursement scheme. Essentially, if you got two that are in order, one of them should pay half back. If you got three, then it would be, everybody splits it by a third. Given all the kind of subrogation issues with tort law and PIP liens and everything else that goes along with that, if you can, invest the time in trying to find some other insurance that might be co-primary, a lot of times that could be an easier, more effective way to go. And that has a 6-year statute of limitations on it for contracts. Property protection, those provisions of 3115-2 that I just talked about, that applies to property protection insurers. So if you got two insurers that would be on the hook for the same loss under property benefits, then they should be able to seek recoupment from one another as well. Also, 3116 should apply to the property protection insurers. So the stuff about the liens and indemnity and things like that. I think it's a rare situation where 3116 would actually be all that useful on a property protection claim. But, I can envision, though, if you're talking about an on-estate accident, that might be more useful. That's something I would probably look into. Interestingly, there's no cross-reference to 3177, though, on those uninsured motorists. Okay, a couple things about common law subrogation here, and I apologize that I've got to kind of start breezing through this stuff, but getting close to the end here. Here's an interesting case, and this is one where state auto paid out PIP benefits. You had an accident. The defendant was a self-insured out-of-state auto owner, and so they brought just a basic subrogation case against them, like an equitable subrogation. Their insured had already brought and settled this claim for non-economic and economic damages in excess of the PIP, which is sort of that situation that we just talked about. So everybody kind of, brushed them off and said, get out of here. But what the court said in that case was that their right of subrogation accrued upon payment of those benefits. And so if the insured had a right to recover medical expenses and lost wages, so did the insurer as a subrogee. I apologize, I see a quick typo there. They also had that right. And so because they had that right before the release was executed and all of that, the insured did not have the ability to sign away the insurer's rights. I like this case. It's kind of an anomaly. There's not really a whole lot of related case law out there to this effect, but I like the principle of it, which says that, all right, you know what, this is your claim to recover from the third party if you also want to pursue that under certain circumstances. I do note that, a lot of this may have depended on the vehicle being an out-of-state auto owner, self-insured outside the no-fault system, but I think it could conceivably, in my opinion, also apply in a situation where, you've got an out-of-state accident, or some of the other situations where tort law would still be available. But, just to sort of have that and be able to bring that subrogation claim even as a PIP carrier is really nice. And this is something I think that would be useful also if you've paid out on, say, maybe med pay or collision claim or something like that. On the PIP side, though, I mean, we've got the other side of this, which is that we have an insurer that paid no-fault benefits to a child, and after she fell off a hayride wagon, brought a suit against the driver of the tractor to recover. And the court there said, nope, 3116 is the only circumstances in which an insurer may seek reimbursement for PIP benefits, paid or payable. So they said there was no out-of-state accident, no uninsured motor vehicle or intentional injury. Carrier did not have a right of subrogation there. And it really didn't matter that they brought their contractual subrogation argument. And basically, the principle here is that, this is one view that says, well, 3116 is the only way that you can recover. I think it runs kind of contrary to that last case, the Velazquez case that we talked about. But this does seem like might be the prevailing view based on a couple other cases that are out there involving some injuries with kind of vehicles and stuff that are outside the no-fault system. Basic subrogation principles here. This is Steinman versus Dillon. This actually was a medical insurer, not an auto insurer, but I think that the principles here would probably apply to, if you've made some medical payments or, maybe underinsured motorists or something like that. They were seeking subrogation claim for recovery of medical expenses. And his basic principles of the subrogee stands in the shoes of the subrogor and it requires no greater rights than those possessed by the subrogor. So if, basically it's the principle that if the insured has a tort claim, conceivably you would have the tort claim and you'd be able to recover, but you've got to look at those sort of tort limitations and all of that stuff, and you're going to have the same limits that they do. Made whole doctrine. Here says carrier has no right of subrogation where the insured's loss exceeds his recovery from his insurer, and the tortfeasor after deducting attorney's fees and costs. That's kind of an odd formulation going back to 1919. To be honest with you, I don't really run into a lot of made whole problems in Michigan, but they do technically have it, as well as common fund, which is not surprising. I think just about every state's going to go along with that. So the insurer who benefits from a fund created by an insured's attorney must pay a proportionate share of costs and fees. I think we're all pretty familiar with that. Coordination of benefits. This is another way that you can, conceivably look to subrogation. So I guess what I'm suggesting here is if you've got somewhere else that you can look, because of all the tort problems that you have, so if you're looking at subrogation, well, why not be subrogated to a health insurance contract or something of that nature, or some other kind of coverage where you don't necessarily have to worry about tort liability. You can use that equitable subrogation principle and pursue something more on a contractual liability basis. So we know that you can offset or exclude coverage where other health and accident coverage is. So you could conceivably subrogate on that contract with a 6-year statute of limitation, but everything depends on the policies. Okay? If both policies are coordinated, the health carrier is primary automatically. It doesn't matter who uses better adjectives or what. Just because the statutory authorization of the PIP coordination clause that automatically makes the health carrier primary, and you can pursue that. If neither policy is coordinated, oddly enough, the insured can double recover. I'm a little astounded by that, but that's the way that they do it. And if only the health policy is coordinated, so your no-fault, your PIP policy is not then your primary, and you'd not be able to really recover too much on that claim. Self-funded ERISA plans. They're going to they basically, in short, because I got to apologetically gloss over this a little bit, because you're a self-funded ERISA plan, you've got preemption principles that come into play, and so in the Sixth Circuit and the Michigan federal courts, they say that their coordination of benefits clause can actually trump the no-fault clause. But it's not always necessarily there. So it's really important to look at plan language, policy language, make sure you're comparing those two policies. And also, if the plan's not self-funded, then you should have the same rights than you would ordinarily have as against like health carrier. This is basically, this is more useful, I think, from the other side. But a lot of times what happens, this is more about actually PIP liability. I'm going to have to skip over this one, but this is more just about the ERISA plan seeking reimbursement from the beneficiary, and then, you know, the PIP carrier then has to, in turn, reimburse the insured again. It's a little screwy, but another good reason to always keep looking at your plan language, policy language, make sure you know exactly who's got what cards in their hand. Workers' compensation, those benefits are automatically offset for work comp. So conceivably, if your insured gets a work comp recovery, you could try and seek reimbursement from that. You could, you know, I would definitely try and seek recovery from that comp carrier also. Applicable statutes and limitations here. Personal injury and property damage are 3 years. It also includes products liability is also 3 years, and medical malpractice falls under that too. So they're all 3 years. Contracts, if you're pursuing another carrier, you're looking at a 6-year statute of limitations. So that could be either another PIP carrier, or it could be an insured's health carrier or something along those lines. And reimbursement under 3116. So if you're seeking reimbursement from the insured because they got paid and you think you've got a legitimate lien, you've got 1 year from the date they received their money to file a lawsuit. And I believe that would apply to the indemnity as well. So now we are at our conclusion here. I'm hopefully got my questions here, and I'm trying to see. Okay, our trivia winner, first of all, is Shelley Monroe. So Jamie Breen will email you to find out which book you would like following the webinar, because she had the correct answer to the question, what was the original name of the University of Michigan? And I'm going to try to pronounce this correctly, but it was Cathalepistemian. Cathalepistemian was the answer to that one. So congratulations to all of you who got that, and especially congratulations to Shelley Monroe. So she will be following up with you. Okay. Here's an interesting question. Can an insurer recover for criminal restitution? That's a really interesting one, and actually I think I came across that pretty recently, and I don't recall off the top of my head if there is a specific case dealing with it, but I do know that there is case law out there that would support the proposition that an insurance carrier would be entitled to recover for criminal restitution. And I think the basis for that was along the lines that it's not based in tort liability. Criminal restitution comes from another source. It's like statutory. It's criminal law. So it was actually, I think someone was able to recover on some property loss or something like that. But definitely it is a possibility. So I would look at it if it all is possible. How does Michigan subrogation work for municipalities and public entities? You know, it's basically going to be the same thing. There's case law out there to the effect that, if I recall correctly, sovereign immunity is not necessarily waived for motor vehicle related accidents, but the No Fault Act does apply. So basically you're going to have to go through 2 hurdles, which is first, everything that I've just talked about with the tort liability, with the subrogation rights and everything like that. And that would be only after, you know, you can kind of deal with all the municipality and notice of claim stuff that you're going to have to go through. I do have a number of other questions. I will be happy to follow up with you all who asked them after the conclusion of this broadcast. I thank you all for listening and hope you enjoyed our webinar today. And I certainly hope that you will take a minute to give us your comments and questions after this is over. And if you ever have any questions or want to discuss any particular issue with me, feel free to give me a call or email or follow us up through the webinar here. And thank you very much.